apologize to my family, especially my kids.
This was a serious operation. A long prison sentence is necessary. Will Owens, case number 25 CR 43184. Present before the court is Mr. Owens, right?
Yes, sir.
You're Mr. Owens, right?
Yes, sir.
Represented by Mr. Washington. We have Mr. View from the prosecutor's office, Officer Tork from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
We have, Judge.
Yes, Your Honor.
Is there any reason not to go forward with sentence today?
Oh, Your Honor.
Prepared to move forward, Judge.
All right, as a preliminary matter, Mr. Owens, you have been provided, you and your attorney have been provided with a notification, which is you're going to be receiving what we call a Reagan-Toke sentence. That means you're going to both receive both a minimum and a maximum term. It's presumed that you're released at the minimum term, but the Department of Rehabilitation and Corrections may, under certain circumstances, keep you up to the maximum penalty. That is all set forth on the notification. This is yours to keep. I'm going to attach this to the sentencing entry as Exhibit 1. And do you have any questions about that, or do you want me to read this to you?
No, sir.
Are you satisfied that you understand the Reagan-Tokes or indefinite term to your sentence?
Yes, sir.
All right, we also have a mandatory period of post-release control. That means the adult parole authority is going to supervise you for anywhere from 2 to 5 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence, or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. I'm going to attach this as Exhibit 2. Are you satisfied that you've been notified about post-release control?
Yes, sir.
All right. We have 0 days of jail time credit. Does that sound right to everybody?
Yes, Judge.
Yes.
All right. Mr. View, on behalf of the state.
Your Honor, in terms of the state's recommendation and discussions with defense counsel in terms of our negotiation, I did agree to limit my recommendation to 11 years. And we, in discussion with the court, the state's recommendation is to count 8. That is a first-degree felony, a minimum definite mandatory period of 7 years to a maximum indefinite term of 10.5 years. As to counts 1 and 3, 24 months in prison, each of those to be served consecutively to each other and consecutive to count 8. And as to counts 14, 18, 22, 26, and 33, each of those a 7-year prison term to be served concurrently with count 8. That is a minimum definite mandatory term, a minimum definite term of 11 years to a maximum indefinite term of 14.5 years, of which 7 years is mandatory. There is forfeiture for the $3,693 that was seized from the defendant. That's to be forfeited to the Warren County Drug Task Force. I think that covers all of the things that we negotiated and specifically discussed, Your Honor.
Mr. Tork, anything from probation?
Nothing further this time, Your Honor.
Mr. Washington?
Judge, that is what we discussed. We'd ask for to impose a sentence with the 7-year mandatory term.
Mr. Owens, is there anything that you would like to tell me?
Yes, sir. I know what I did was wrong. I mean, I'm accepting my guilt. I want to apologize to my family and to the courts, especially my kids, for making them go through this long journey we finna take.
So here's the thing about this case, Mr. Owens. The plan is to break this potentially down into a 2-part case. And I am going to send you to prison. There's a mandatory prison associated with this. I am going to sentence you to the 7 to 10.5 years in prison on the first-degree felonies. That means that it's presumed that you're released at that 7-year period. But the Department of Rehabilitation and Corrections can, under certain circumstances, keep you up to the maximum penalty. That's on the mandatory part of that. Then I'm going to sentence you to 24 months on each of the felony 3s. Those are going to be all consecutive to each other. So your total sentence, even though we do months and years, it's kind of hard to keep up with, but you're going to receive a sentence of 11 to 14.5 years in prison. If you behave yourself while you're in prison, I will consider releasing you on judicial release after you have done the mandatory time. If you behave yourself while you're there, that would then complete the punishment portion of that, and then we could get on to the rehabilitation and supervision part of that, which might include, drug testing, treatment in a facility, something like that. But this was a serious operation, and a long prison sentence is necessary, both to protect you and to properly punish you. I do find that you're indigent for the purposes of fines and costs. There are not going to be any financial sanctions. This also includes the mandatory period of post-release control that I told you about a few minutes ago. Also, we have a consecutive sentence, which means that this sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you, and I find that no one sentence would properly punish you, so I need to impose consecutive sentences. And you do have a prior for trafficking, so your criminal history suggests that a criminal sentence is also necessary. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, those will all be provided to you without charge. Is there anything else we need to do, or anything that I forgot?
No, Your Honor.
No, Judge, thank you.
All right, I am going to remit you to the custody of the county sheriff pending transport to the institution. Good luck to you, Mr. Owens. We have Officer Evans and Officer Wilkinson.
Under Ohio Revised Code Section 2925.03, trafficking in drugs is prohibited when a person knowingly sells, offers, prepares, or transports a controlled substance. The degree of the offense depends on the type and amount of controlled substance involved. In this case, Will Owens was sentenced after pleading guilty to multiple felony drug-related offenses connected to a large-scale drug operation. The court considered the seriousness of the conduct, Owens' prior trafficking conviction, and his criminal history when determining the appropriate sentence. Under Ohio Revised Code Section 2929.11, felony sentencing must consider the purposes of punishment, deterrence, rehabilitation, and protection of the public. Under Ohio Revised Code Section 2929.12, the court evaluates factors relating to the seriousness of the offense and the likelihood of future offenses. The court found that a community control sanction was not appropriate and that consecutive prison terms were necessary because a single sentence would not adequately punish the conduct or protect the public. Owens received an aggregate sentence of 11 years minimum to 14.5 years maximum in prison, including a mandatory prison term, consecutive sentences on additional felony counts, mandatory post-release control, and forfeiture of $3,693 connected to the offense. The sentence reflected the court's finding that the scope of the operation and Owens' criminal history required a significant prison term under Ohio sentencing law.